Hello everyone, my name is Princess Joan, the Chair of the International Law Commission, and for the module today, we will go through the rules of procedure that are used in the plenary of the International Law Commission. We see that the Chair of the International Law Commission is the custodian of all the powers and functions of the ILC. The chair is the spokesperson of the ILC and is the final authority on all matters touching on the interpretation and the application of the rules of procedure. So procedurally, the chair shall declare the opening and closing of each plenary and preside over the plenary. In absence of the chair, the deputy chair will carry out these functions. The plenary is composed of the deputy chair, the chair, rapporteurs, and commissioners, who shall all times refer to each other as commissioners. For example, when referring to your friend in the ILC plenary, you will refer to them as Commissioner Agnes, Commissioner Sonia, and so on and so forth. For the dais members, who are the chair, the deputy chair, and rapporteurs, they will be referred to as Rapporteur so and so. Therefore, for example, when referring to the chair, you will refer to them as Rapporteur Princess. For language, all proceedings in the plenary should and must be conducted in English. When referencing the dais, all requests to address the plenary and raise any matter in the plenary shall be channeled through the dais. Furthermore, a commissioner who is speaking to a motion shall address the dais at all times. When a commissioner is on the floor, the commissioners must listen and must maintain silence while a commissioner is making their submissions. With regards to recognition, all commissioners must be recognized by the dais before they address the plenary. Furthermore, when a commissioner is speaking to a motion, they must address the dais at all times. At the beginning of the plenary, a commissioner must register themselves as present and voting and will be recognized as such. Remember that only commissioners who had previously submitted their draft articles will be eligible to present their work in the plenary. Commissioners who are absent during roll call shall send a note to the chair, deputy chair, or the rapporteurs wishing to be recognized as present and voting. Failure to do so will mean that you are not granted audience in the plenary. For purposes of the rules of procedure, the phrase present and voting simply means that the commissioner is present in the plenary and they can cast either an affirmative or negative vote with regards to the draft principles that will be formulated at the end of the plenary. When voting present and voting, the commissioners will be asked to either raise their placards or raise their hands so as to be recognized. With regards to voting, in the plenary, the commissioners shall vote in the same way by either raising their hands or raising their placards. Each commissioner is entitled to only one vote. All motions and matters under consideration will majorly pass with a vote of simple majority. In the case of a tie, the chair shall have a casting vote but may delegate the right to vote on this to either the deputy chair or any of the rapporteurs. No commissioner shall interrupt the voting process except on a point of order. We shall now look at the motions that are used in the plenary in the International Law Commission. A motion is a proposal made for the purposes of extracting a decision in the plenary. The first motion is a motion to start the plenary. This is raised by a commissioner requesting for the plenary to commence. It passes with a simple majority. An example of raising this motion is simply a commissioner stating, "Motion to start plenary." The second motion is a motion to move into the first reading. The motion is raised by a commissioner who wishes for the plenary to discuss the topic at hand in a formal setup. Here, the rules of procedure apply strictly. A commissioner moving a motion into the first reading must mention the cumulative time for the plenary and the speaking time for each speaker and the topic at hand. Therefore, an example of raising such a motion would be a motion to move into the first reading for 180 minutes, 9 minutes per speaker, to discuss the immunity of state officials from foreign criminal jurisdiction. We see that the motion has mentioned what the motion is for, how many minutes the plenary should take in the first reading, and how many minutes each speaker should take, as well as the topic to be discussed. The dais has a discretion to suggest a more appropriate plenary length or speaking time, or rule the motion out of order without the possibility of appeal. The motion requires a simple majority to pass. The third motion is a motion to move into the second reading. The motion is raised by a commissioner who wishes the plenary to move into a setting to discuss the topics in an informal setup, for example, groups. Here, the rules of procedure do not apply strictly, and the commissioners are not penalized for non-observance of the rules of procedure. Similarly, a commission who is raising a motion to move into the second reading must mention the cumulative time for the plenary and the topic at hand. However, there is no specific speaking time for each speaker, as this is an informal setup whereby they will be in groups. Therefore, an example of raising this motion would be a motion to move into the second reading for 200 minutes to discuss the immunity of state officials on criminal liability from foreign criminal jurisdiction. The motion also requires a simple majority vote to pass. The fourth motion is a motion to extend the plenary. This is raised when a commissioner would like the previously set time to be extended. Extension of the plenary can only be done up to half of the initial set time. Therefore, if the first motion set the time to be 200 minutes, when raising a motion to extend the plenary, the motion can only read up to 100 minutes. It is half the time that was previously raised. The motion is called up just before the end of the plenary time. Therefore, if the plenary was to run for 200 minutes, 5 minutes before the end of the plenary is where a motion to extend plenary is raised. This motion is not subject to a simple majority, but rather implemented under the advice and the discretion of the dais. The fifth motion is a motion to adjourn. It is raised by a commissioner requesting the plenary to suspend its activities until the next scheduled meeting time. This motion is also not subject to a simple majority vote, but rather to the discretion of the dais. Either of the dais members may rule the motion out of order without the possibility of appeal. A simple way to raise this motion is for a commissioner to state a motion to adjourn the plenary. So the motion may be utilized, for example, where the commissioner seeks to break for lunch for the day and commence at a later time in the afternoon. The sixth motion is a motion to amend a motion. We see that a commissioner may have previously raised a motion. However, they seek to amend that motion. The first thing to note is that a motion may only be amended by the same person who had raised up that motion in the first place. So a mover of a motion may move to amend their original motion. And an amendment may take one of the following three forms. The first is that they left out certain words and they wish to include them. The second is that they want to add or insert certain words. The third is a combination of the two. Once again, a motion may be amended on three grounds. First is that they want to leave out certain words they had previously put in the motion. Second is that they want to insert certain words that they had not used. Third is a combination of the two, whereby they want to leave out words as well as include others. An amendment may be moved at any time after the original motion has been proposed, before the motion is tabled for voting. Therefore, once a motion has been voted on and has been passed, it cannot be amended. A motion to amend does not require a vote. Once a motion is amended, it's amended. That's the end of it. The seventh and last motion used in the plenary for the ILC is a motion to withdraw a motion. Here, we find that a motion may be withdrawn by the commissioner who previously brought it up at any time before the voting on it has commenced, provided that the motion has not been amended. Simply meaning that the motion to withdraw a motion first can only be withdrawn by the same person who brought up the motion. Second, that it can only be withdrawn before it is voted upon. Once the motion is voted upon and it is passed, it cannot be withdrawn. A motion that has been withdrawn can be reintroduced by any commissioner, but it is only subject to the withdrawal. If the motion has not been withdrawn, another commissioner cannot reintroduce it. A motion to withdraw does not also require a vote. Once it is withdrawn, it's declared withdrawn. Next, we will move to the points and rights that are used in the plenary. The general rule with regards to points and rights is that you cannot interrupt a commissioner while they are speaking during their speech. Interruptions are not allowed. However, there are exceptions to this general rule. There are 3 points that can interrupt a speech at any time except during voting. The first point is a point of order. A point of order is raised at any time during the discussion, and it is raised by a commissioner where they feel as though the rules of procedure are being improperly applied, abused, overlooked, or not being observed by the fellow commissioners or the rapporteurs during the plenary. The rapporteurs have the discretion to rule on the validity of the point of order with accordance to the rules of procedure. And where a point of order is raised in an improper manner, it will be discarded with no possibility of appeal. Please note that a commissioner raising a point of order must strictly raise it on the rules of procedure, and it must not touch on the substance of the matter under discretion. This means that when you're raising a point of order, it can only be where rules of procedure are not being properly applied. It cannot touch on the topic at hand being discussed. The second point that can interrupt a speech is a point of personal privilege. This is raised by a commissioner where there are conditions within the plenary that interfere with their capability to fully participate. An example of this will be where the room is too stuffy and the commissioner is having a hard time breathing, or where the commissioner needs to visit the washroom. This is where you raise a point of personal privilege. The third and final point that can interrupt a speech are orders of the day. These are raised by a commissioner where they feel as though the issues being deliberated upon have gone off track and do not speak to the agenda of the day. For example, The matter under consideration would be with regards to how diplomats should be treated in international law, and the commissioner who is at this stage of the plenary speaks to the application of treaties. We see that this is a different topic that has gone off track from the topic that is supposed to be deliberated upon. This is where a commissioner raises orders of the day. Following the general rule, there are 4 points that cannot interrupt a speech at the plenary. They can be raised at any time except when a commissioner is speaking in front of the plenary. The first point that cannot interrupt a speech is a point of parliamentary inquiry. This is raised by a commissioner where they seek to inquire about the rules of procedure at any point where they don't understand them. A commissioner can raise a point of parliamentary inquiry to any member of the dais seeking clarification on any rule of procedure. However, this can only be raised before the plenary begins or after the plenary ends. Once a commissioner begins to speak, another commissioner cannot raise a point of parliamentary inquiry at any time. The second is a point of information. This is raised by a commissioner where they are seeking clarification on a statement that has been made by a previous commissioner while they were making their submissions. A point of information is essentially a question. So it's asking a question to another commissioner on something that they have previously said. A point of information is a brief statement referencing the speech of the previous commissioner, followed by a short question. Ideally, it should not exceed 60 seconds. The third that cannot interrupt a speech is a right of reply. A right of reply is a concept specific to points of information. So this is raised by a commissioner where they would like a reply to a point of information that they had previously raised. So essentially, a commissioner wants a reply to the question they had previously asked. A right of reply is raised to the rapporteur, and it is at their discretion to allow the right or to deny it. The rapporteur may also request that the commissioner submit the right of reply in writing for further consideration before granting it. The rapporteur has the discretion to set a time limit for the right of reply, but it's otherwise set at 60 seconds. No commissioner shall call for a right of reply to a right of reply. Essentially, this means that no commissioner is allowed to call for the chance to answer a question to a question that has already been answered. An example would be where a commissioner raised a point of information to another, the question was answered, and now you want to ask a further question. That is not allowed. Once your question has been answered, you are not allowed to ask a follow-up question to the answer. However, a right to reply to a right of reply can be allowed under the discretion of the dais. However, it is very, very discouraged. The final point that cannot interrupt a speech is yielding. Yielding is done by a commissioner once they are done presenting on their research. A commissioner may yield the floor to two options. The first is yielding the floor back to the chair or yielding the floor back to the dais where they have exhausted their presentation. The second option is yielding the floor to another commissioner where the time has not been exhausted and they are yielding the floor to a commissioner who supports their arguments if the other commissioner agrees. Those are the rules of procedure. Thank you.